So next up we have Ryan Featherstone. Ryan is a real estate attorney here in Sarasota. He grew up in Sarasota, went to University of Florida, so definitely a local person, and he definitely gets into the weeds about a lot of really important stuff associated with purchasing a home in Florida. So without further ado, here is Ryan Featherstone.
Good morning. My name is Ryan Featherstone. I'm an attorney in Sarasota, Florida with the law firm of Dunlap and Moran. I was born and raised in Sarasota, Florida, and I've practiced in Sarasota, Florida my entire career. In my 16th year of practice. My personal practice is in real estate law. I focus my practice on residential and commercial real estate transactions, as well as business transactions, purchase and sale of businesses, and off that, pretty much everything that relates to real estate, whether it's contract drafting and negotiation, leases, disputes, you name it. The main focus of my practice is on probably at this, especially in this current market, is residential transactions, purchase and sale of homes, primary residences, second homes, investment properties, and all the collateral work that comes with that, whether it's creation of business entities for investment property purposes, leases, all the various issues that arise during a closing transaction. The firm that I work with, Dunlap and Moran, PA, has been in the market 30 years. We're about 13 attorneys strong at this point between our two offices in Sarasota and Lakewood Ranch. Obviously, one of our main focus areas is real estate law, but I would say our other main focus area is estate planning, which encompasses your wills, trusts, probate, powers of attorney, healthcare documentation, guardianships, and then we also have a pretty robust litigation department that has fed a lot of work from both the both the real estate departments as well as the estate planning departments. But we do various other practice areas as well, corporate law being one of them. So that's a little bit about me. And the firm, and happy to discuss any topics that you might have.
So Ryan, if you would tell me why somebody would be interested in hiring an attorney to conduct a transaction, because oftentimes people in Florida simply do the transaction through a title company.
Yeah, so obviously in Florida, we have a lot of folks relocating from other states, other countries, which is even more common in this climate. So we do have a lot of explaining to do about the differences between states, because there are vast differences. Some states, the real estate attorney drives the bus on the transaction. Others, it's non-attorney title companies. So, and even frankly, folks that are Florida residents have confusion about that. In the state of Florida, the way it works is that if you're closing a transaction, you have a choice. You can either choose a real estate lawyer or firm, or you can use what I call a non-attorney title company. The distinction is that at the end of the day, the goal, the end goal of using either is to get the transaction closed. However, a non-attorney title company is there to close the transaction and does not have a client. They are ethically and legally limited to what their scope of representation is, which is really essentially, for lack of better words, representing the transaction. They can't be a legal advocate for either party. They are there to, close the transaction, issue the title insurance, do the documentation, hopefully correctly and competently. However, neither party has actual representation. Now, a lawyer or a law firm that's involved in the transaction does have a client. We are ethically and legally bound to have a client. The client is typically the party that is paying for our representation. So in the contract, obviously, it's clearly spelled out which party to that transaction is selecting the closing agent and paying for those services. That typically, obviously, is the client. When we send out letters at the initiation of a transaction, we define the scope of our representation and clearly define who or what our role is, I should say, to both parties. If a buyer selects us to represent them in the transaction, not only do we close the transaction like a non-attorney title company, but we represent that buyer in the transaction. So should there be any issues related to title, related to survey defects, related to anything, we will represent the buyers as their advocate and ensure that their rights are protected, that their deposits are protected, and that the transaction closes in accordance with the contract. If there's survey defects, title defects, we will timely object on behalf of the buyer regarding that. A non-attorney title company cannot do that. If there are title defects or survey-related defects, the non-attorney title company has a duty to disclose those, but they cannot take a legal position on behalf of either party. They would have to refer that person to an attorney in order to do that. The other huge misconception between the two is that a lawyer either charges more or is going to kill deals. On the issue of cost, that is a complete misconception. Matter of fact, I've been doing this 16 years. I've seen many non-attorney title company title quotes or closing statements where the fees were substantially more than what our firm charges, for example. So the reality is that if you select a lawyer, you're really paying the same, many times less than what you might pay for a non-attorney title company, but you also get the benefit of having that legal representation.
Thank you for that. One of the most confusing things that people call me and ask me about is, how do I take title to the property? I mean, everybody understands that fee simple means that you're buying the property and the building, but can you explain the differences of deeds?
Sure. So when you talk about deeds and vesting of title, at the limited level, or at the base level, it's there's three options. If you're taking title on an individual basis, Mr. and Mrs. Smith are taking title to a property. There's three levels. You can either take as tenants in common, joint tenants with rights of survivorship, or tenants by the entireties. When it's husband and wife, you would want to, I don't see a reason not to, take title other than as tenants by the entireties. And the way we do that in Florida is we vest the title on the deed at Mr. and Mrs. Smith as husband and wife. That language, husband and wife, creates a tenancy by the entireties. And with that come a couple of things. Number one, survivorship rights. If one of the spouses was to pass away, the interest of the deceased party goes to the surviving spouse as a matter of law at the time of death. Nothing needs to be probated. You file a copy of the death certificate in the clerk records, and you're done. The surviving spouse now owns title 100% in his or her name. The other thing that comes with tenants by the entireties ownership is some creditor protection. So the law treats the husband and wife as almost like one unit, like its own entity. So when you're talking about creditor claims, the individual creditors that may attach to either the husband or the wife on an individual basis do not attach to assets that are titled tenants by the entireties, husband and wife. Joint creditors potentially would have a claim, but it would have to be against both the husband and wife. So if the husband has a judgment against him for $5,000 for his credit card bill, that would not attach to assets that are titled as husband and wife. So there's a couple of benefits there when you're talking about marital couples. And that would obviously be always the recommended way to vest title for them. Joint tenants with rights to survivorship is the situation where two folks are taking title together, but they want the same survivorship rights that come with a tenants by the entirety situation, husband and wife, but they may not be married. Fiancés, boyfriend and girlfriend, family, friends, business partners. Anyone who is taking title together where they want that survivorship right included. If one of them was to pass away, God forbid, the deceased party's interest would go to the survivor at a probate at the moment of death. Same as with husband and wife. Tenants in common is the lower level, and that's where, let's say, two folks are taking title together 50-50, but there are no survivorship rights. So again, God forbid one of them was to pass away, that 50% interest would not automatically go to the other party. That 50% interest would then descend pursuant to that person's will. Hopefully they have a will. Or if they don't and they're intestate, then that would be pursuant to the Florida intestacy statutes. That interest would need to be probated because it doesn't have that automatic survivorship rights. But that interest would then descend to the heirs and devisees of that deceased person, and vice versa on the other side. So that's, at its most basic level, kind of the distinction. But of course, in addition to those types of titling, there's all kinds of other top options. You can do business entities, LLCs, corporations, etc. Trusts, and there's a variety of different trusts, revocable, irrevocable, estate planning trusts, Florida land trusts. There's a wealth of options when it comes to taking title.
So if I were going to take title to a property and I decided that I'm going to put this in a trust and I don't have a trust, how long would it take you to form a trust? Could that be done during, say, the 30 or 45 day period that you're doing a transaction?
Yes. So when you're talking about trusts, you're talking about, more of the estate planning type attorneys that are involved in drafting wills and trusts. From a personal standpoint, I don't prepare wills and trusts and do that. I have a department at my firm that have attorneys that do that. That is their sole area of practice. But the situation you just spoke of comes up often, whether it's folks that are already here or out of state. The out-of-state situation arises a lot where folks are relocating here. They may be coming here from New York, and they've been residents of New York for years, and so they have all this stuff done. They have wills, they have trusts that have been created in New York, but now they're moving here, and they're going to be here full-time, and they're going to establish residency here. During closings, we often get asked about that situation. Yeah, is my trust in New York, sufficient? And it may be, it may not be. Florida has very specific homestead laws, and you have to be very cautious when you're making Florida your state of residence and Florida property your homestead, that anything in that trust doesn't violate the Florida homestead laws. So my recommendation in that situation is always to have whatever has been previously prepared, reviewed by our estate planning department, and they will give the guidance, whether it's amending and restating, i.e. starting over with a Florida trust, Florida will, or perhaps just amending what previously exists, codicils and different things like that. If they don't have anything and they're starting from scratch and they want to establish a trust here to take title, we can do that as well. The timing on it is whatever the client need is, but it also involves proactive cooperation by the client. If a client is in the process of getting a loan and doing due diligence on the property, they got a lot on their plate. So they're focusing on getting inspections done, focusing on getting all the information they need to the lender, tax returns and all of that to get approved for the loan. To put that on their plate sometimes is a lot. So sometimes it's something that we try to do after the closing with the cooperation of the lender, because of course the lender, if they're financed, would have to be involved in that. But certainly, yeah, we've done many transactions where we were able to get the trust established executed, because there's a formal execution process to do that. And then once it's fully signed, executed, etc., then you can vest title in that trust. So absolutely. But I would involve another attorney from my firm if they decided to hire us to prepare the trust, to get involved and sit down with that client, consult with them, and make sure that they have their estate plan squared away.
Ryan, that's some great information. I was wondering if you could just kind of touch on 1031 exchanges. We have a lot of investors that are buying property here, and they're interested in sheltering that money, or at least avoiding some capital gains tax by doing a 1031 exchange.
Sure. 1031s are actually becoming a very hot topic again. We get a lot of calls on these emails as well. And, because the market is what it is, a lot of folks with investment properties are trying to sell at the height of the market. And so when you have investment or income producing properties, 1031 is an available option. Additionally, there are some rumors that the 1031 may be going away. So I think people are trying to capitalize on that as well. So of course, the idea of the 1031, which is an IRS code, allows an owner of an income producing property to sell that property. And of course, if they just sold it, nothing else, they would have obviously capital gains taxes. So in order to defer that, you can utilize the concept of 1031, which is you sell the property within certain very specific time frames that are very strict. You have to acquire what's called a replacement property for this property that you sold, which is the relinquished property. And if you do that in compliance with the rules, you do not have any capital gains taxes at that time. It doesn't avoid capital gains taxes, it defers capital gains taxes. So the idea there is when you sell the property, the income producing property, you have 45 days to identify what's called the replacement property, which is the property that you're going to roll the gain into. And then you have 180 days from, and both of these timeframes start from the day of closing of the property you sold. You have 180 days to actually complete the second closing. But again, it can be very complicated. There's specific rules that apply. For example, when you sell the property that is the relinquished property, the funds from that sale cannot go to the seller. If they do, that's called what they call cash boot, and that's taxable. So you have to involve what's called a qualified intermediary, or a 1031 exchanger. And that party will then actually escrow those funds for the seller until the replacement property closes. And at the time of the closing of the replacement property, that third party who's holding the funds utilizes those funds for the purchase. They will actually send the funds to the closing agent who closes the replacement property or the purchase. And by doing that, the seller never holds those funds. Since the seller never held the funds, there's no boot and there's no tax. That's the conventional way. There's also reverse exchanges, and there's all kinds of stuff. Rules that apply if the property that's sold has a mortgage on it. They have to, the replacement property has to also have a mortgage on it of equal value. All kinds of very nitpicky rules and areas where you can trip up and end up having boot, or basically messing up the whole 1031 entirely. So that is why it's very important to utilize the services of an attorney, real estate attorney, as well as a qualified intermediary. We locally use the services of some local qualified intermediaries that have been doing it a long time, that we trust, that we know are going to do it correctly, guide the client correctly as far as holding the funds, and there's a lot of paperwork that goes along with it. But if done correctly, it is a great tool for folks that have investment properties, especially now because they're trying to sell at the height of the market, for deferring those taxes.
Thank you, Ryan. You've given us a lot of information. I think it's just the beginning of some questions. And if somebody did want to reach out to you, how would they do that? So
they can contact me at the office at Dunlap and Moran. Phone number is 941-386-8255. 366-0115. And of course, my email is always available as well. Email address is rfeatherstone@dunlapmoran.com.
Thank you, Ryan, for your time today.
Thank you.
All right, guys, that wraps it up. The most important thing I wanted to stress is that this is just the beginning. These people have all made themselves very available for you to call. We've left all of their information below. If you're watching this on YouTube, I will include each one of their names and all of their contact information as well as their websites below. Just check that out in the link. If you're watching this on our website, it will also be below. And I can't stress enough, please reach out to these people. They've made themselves available for you. They want to help you. And this is just the beginning. Please do not hesitate to call me, contact Gary. We would be happy to work with you. There's a lot of things we can do remotely. All the agents here are doing, FaceTime or video showings to kind of get the ball rolling and help you out in this market. So thanks for joining us, and we can't wait to speak with any of you directly.